As always, we would like to say a big thank you to you for joining us here. On Scale of Justice, I'm Uyi Agumofwegbe. In this edition, we turn our attention to a public interest litigation, one very important aspect of the law that most times we do not pay attention to, particularly people who are not within the legal profession. However, this is one area of practice that also has a very strong element in terms of how it protects the rights of citizens and even corporate entities. On the program today, we'll take a look at the core variables in this conversation, what lawyers have to tell us about it, what citizens must know about it, and how exactly it is peculiar in the case of Nigeria, given the uniqueness that also forms our reality as a country and, of course, as a government. We'll take a quick break. When we return, my guest will walk us through what we should know in the next 25 minutes. Do stay with us. Incidentally, my guest today is a lawyer and a public affairs commentator, Barrister Alexander Ogbo, who would help us understand what the nitty-gritty is regarding this discussion. I'd like to say a big thank you to you for coming on the program.
It's quite a pleasure. It's always an opportunity to contribute to societal development.
And we do not take that for granted. But let's begin with the basics, right? When we talk about public interest litigation, what exactly does it mean from not just a legal perspective, but in such a way that the average viewer would understand?
Yeah, public interest litigation has to do with matters where lawyers mostly, and at times non-lawyers, may want to, get it kick-started to get an action in court in process in pursuit of the interests of the generality of the public. Things that happen that, you expect those in power to do something to solve the problem, but they are not interested in doing that. Maybe there could be public outcry, and after that, nothing happens, and people are suffering. So someone decides now to go to court to sue the government or the body responsible for doing an action to make sure that something happens for the good of the generality of the public. So you sue the government or you sue a body in order to pursue a result that will solve an interest that is helpful to the ordinary man, and to everybody. That's what we mean in a simple term by public interest litigation. There are certain things that we want the National Assembly maybe to look into, just like we are talking of this issue of insecurity and the rate at which the government is going. They are not performing optimally, and things are getting out of hand. Someone now decides to sue the National Assembly to court that they are not prompting the government to do the needful in tackling insecurity. Someone may decide to sue, either the Attorney General of the Federation, and perhaps join aspects of the presidency to make sure that they are called to order to sit up and do the needful. So that is a typical example of what you call public interest litigation, to achieve a purpose that will serve generally the public. That's
in the case of Nigeria, it doesn't look so much of an easy, if you like, task, because of maybe, they say the wheel of justice in Nigeria turns very slow. So let's talk about that uniqueness in terms of our legal system, our judicial process in Nigeria. How much of challenge does he, if you like, pose for public interest litigation?
Exactly the speed of the courts quite affect a lot of things negatively here. in a very painful way, you know. But still, at the end of the day, like we say, the way of justice may grind slowly, but surely it will come to happen. The rate at which the legal process moves is quite slow here, as at now, and it weakens some of these matters, you know. It's quite challenging, like you rightly pointed out, because in pursuing such matters, you know, the person following up instituting the action and following up the action is most likely the financier. You are using your own money. We call it pro bono, you know, free service to pursue such a thing.
On behalf of a larger majority.
On the larger majority, even on behalf of the whole nation,
right,
or a section of the country. So that delay has a way of dealing with your pocket and all that. But knowing what actually you are targeting, you endure to ensure. And at the end of the day, by the time the result comes, it's quite encouraging to get a result. You know, it's just like a typical example, maybe some segments. Look at what is going on now, issue of kidnapping young people from schools. Someone can decide to take up an action against the government for the interest of our young ones, our teenagers, who are supposed to be in school and are protected, knowing that time is running. If you put them out of school, it will work against them. So someone can pick up an action that we need the time frame with which these children should graduate to be maintained. It should not be interrupted, and therefore they should be secured, and their school system should be able to run instead of getting them to waste their time even at their prime. You know, someone can take up an action on that. The government should make sure that our school system, especially at the secondary school level, should be in place and maintained and allowed to run, and young ones should safely be allowed to study. That's just a typical example. There was also the case of, where some people raised the issue about NYSC. There was this lady that was insisting she needs to use a skate instead of trouser. And there are others who are also within that framework. So someone can take up a matter in that regard. That way, there's need for flexibility. If somebody says because of your inclination, religious, whatever, you are not to use trouser, the person should be allowed to use skate. So in such matters, when pursued, come under this issue of public interest litigation. In fact, it covers a whole gamut, quite a large space of things that affect the public. You know?
It is my assumption that there are distinctive elements between public interest litigation on the one hand and class action on the other hand.
Definitely.
Would you highlight those for us?
No, certainly. You know, when you want public interest litigation on a general note is wider.
Oh.
Yes, it's wider than class action. It's wider than class action. When you are talking of class action, you are looking at an aspect that has to protect the interests of a particular group of persons. Okay? Something is affecting a wide spectrum of people in the society and needed to be curtailed. For instance, the government starts, let's say there's so much molestation of journalists by a particular government. You know, intimidation, lack of freedom of expression, lack of freedom of movement and speech, and all kinds of harassments of journalists and all. And you discover that journalists are more like becoming like an endangered species. And somebody decides to take out an action that we try to protect journalists in a particular regime. You know, that is a typical example of what you call class action. We say it's sui generis. It's affecting a particular, group. So that's a typical example. But public interest litigation on a wider note covers every other person, every strata of the society. Look at this issue of kidnap for ransom is becoming too rampant now, and it's affecting everybody. Whether you're a military person, whether you're a civilian and all that, and we want to do something to make sure that the government ensure that security, which is the paramount aim of government, is assured. So if you take up an action in that regard, that's a typical example of public interest litigation for the security of every Nigerian. Because, Section 14 of our Constitution places so much emphasis on the issue of security and welfare. So you can use public interest litigation to draw the attention of the government to this effect. All right? So that one is having a wider scope. But class action is a group, something that we take care of a particular group. Their interest.
But again, that's interesting because we understand Section 2 of the Constitution is a bit problematic because we are told it's not justiciable. So how do we marry that?
You see, in as much as on a general note, yes, it's not justiciable, but of recent, certain things have happened that has made the court to, for instance, issue of education. Education is one of those.
Right.
It's not justiciable. All right, but some decisions have come to point to that effect, that sensitive aspects of the life of the people cannot be allowed to be trivialized because you are claiming it's not justiciable. It's just a matter
like primary education.
Yes.
Yeah.
All right. So that is where you discover that some of these things come up and are singled out to be handled. So that the government don't just slip off and waste our resources and waste our time.
As it stands today, I mean, you are a lawyer, you have followed many of these cases.
Yes.
You are not ignorant of what's happening in the public space.
Certainly.
By your own reckoning, would you say we are using these instruments of public interest litigation effectively enough in today's Nigeria?
It is being used. We need more of it. We need more of it. There have been cases where the government took some position, made some decision that is inimical to the progress of the society, and such actions have forced the government to backtrack and go back to do what is expected of them. Because, there are certain things that some people do in the public space, and they feel that they just have the right. For instance, somebody, being in power, you decide to marry a minor. And you want to use one cloak or the other religion or the other to use it to cover up yourself. So when there's a litigation in that aspect, eventually the court will come to give a decision based on the provision of the Constitution as it affects the particular age of the person involved, like implementation of the Child Rights Act. So when such happens, it curtails the excesses of people who should have also now got involved in it massively because somebody had done it and felt that he or she will get away with it. Okay? So it's effective, but we need more. We need more because our government is far flung from effectiveness when it comes to accountability and transparency. For instance, they look at the challenges of insecurity we are undergoing, and someone made a statement that the forests are more like impenetrable to bombs. I mean, that's kind of reckless statement. So with that kind of statement, someone can take up that particular individual, the ministry that made that we need this person to be changed.
Right.
Yeah. When eventually you get the matter through, you see that a change comes. So we have it, but we need more of it. We need more of it because our government, most of our leaders are actually not upbeat with the challenges that we are facing.
As it stands today, there are certain legal instruments we are told are yet to be domesticated at the subnational levels. For example, at the point the Child Rights Act that you mentioned a while ago had not been domesticated in several states across this country. When you look at it from that standpoint, to what extent does this reality limit our ability to, as it were, use or take advantage of the public interest litigation thing?
Even that as it is also calls for public interest litigation, because the states that are not domesticated that can be taken up, they can be sued to court, because we are talking of the welfare of children. that their children, people in power, most of their children they send abroad, they send to highbrow schools, but the children of the lower class of society or class, lower rungs of the society don't have the capacity to get that protection and privilege. But because they themselves are secured using the advantage of being elite, they feel that nothing is happening, whereas a lot actually is going on. Such states can be sued that they must have to domesticate this, because this is something that is beneficial to everybody, and it is a disservice to the government or the people they serve for them not to do that. Suing such states can facilitate their coming up to get it domesticated, because it's something that the benefit is useful for everybody. Where it is not domesticated, definitely abuses occur, and you can't have anything to lay hold on to get somebody to do the needful. That is the disadvantage.
There is this, if you like, you can call it misconception. Some people say it's misgiven about how that if you take the government to court or you bring litigation against the government, your chances are very slim in court. How true or otherwise is that?
It's not overly true. In some cases, you may have some serious, strong oppositions, but we have seen the court in some good number of cases come out squarely to make clear pronouncement that the government must abide by. That is actually what the judiciary is expected to do. There are cases where they will get you hamstring, they really have to twist you using all that they have within their arsenal to make sure that everything doesn't work. But in a good number of occasions, we are seeing the judiciary stand up to their responsibility by making clear pronouncements against the position of the government in power. Definitely, politicians will fight, what they are capable of doing. But a good number of cases, the court has come out against the government. Okay, there have been cases where there were some kind of retrenchment of people, massive retrenchment. Some have been removed from offices, not following the right process. When court actions come, maybe going to industrial court and all that, you see that some people get reinstated. There have been cases affecting some military officers, okay? A good number of them like that. Just because they made legitimate request, they are contending with forces, opposing forces or these terrorists and all that, and they were not given what they were needed to use to fight. And because they voiced out their feelings, they were just sacked, So an action came up in court, and the court ordered their reinstatement in their rightful position. So there have been cases where the court actually had gone against the will and decision of the government. A good number of that. You face opposition quite all right. There's no doubt about it. But most of the time, you put through.
All right, sir. Well, we'll pull through with this conversation as well. But let's take a quick break at this point, everyone. When we return, we'll look at a couple of other things as to whether or not the judiciary itself sometimes become a clog in the wheel of progress when it comes to issues around public litigation. Plus, what more should the public know in terms of the promise in this and the challenge they may also encounter in the process? All of that after this break, please. We urge you to stay with us. Pastor Ogbo, I'd like us to quickly talk about enforcement. I mean, you have talked about a good number of cases where public interest litigation won or carried the day, but we've also seen issues around the enforcement of court judgments in Nigeria. Definitely. Sometimes the other party says we have not been served the CTC of the judgment. Our lawyers are still studying the judgment and things like that. Talk to us about what this means.
There are hitches we face when it comes to enforcement. even at times when you have served the CTC, they will decide to sit on it. You know, some government agencies make things a bit difficult for enforcement to work. For instance, if you do an action against the Nigerian police force and you win, and you serve the necessary processes, there used to be a compliance, but what the police organization have done now is that they make it difficult for you to access any of their bank details when it is issue that is financial, for you to be able to get enforcement through the court.
So you can't garnish in such accounts
yes,
and assets.
Garnish. When you have done garnish and got a result and want to enforce it, to access,
it's not a problem.
It becomes a problem to access any of their bank details that you can. So that's one of the things you have to really struggle with before you can get through. Then, in some cases, you know, by the time you involve some security agencies to go and impound any of the properties, there used to be serious resistance in some cases. You know?
Even with a valid court order?
Yes. There used to be some resistance. You know, you can put through in some, but in some you have some hitches, you know. But by and large, you definitely have to succeed at the end of the day. Only that expenses, you have to
will be incurred.
Incur some expenses to get it done. You could get a garnish order, you know, to impound some vehicles, to seize on some properties and all that. So enforcement used to be a ding-dong battle. But at the end of the day, you can still get results, but not without a fight.
Of course. Does the judiciary in any way, because of maybe bureaucracy and systemic issues, pose a challenge when it comes to public interest litigation?
No, not the judiciary per se. Not the judiciary per se. What the judiciary is up to is come with the right process. Come with the right process, you know, file the right things, the right documents, get the right facts and evidence. That is what the court is actually interested in. So that the court will have things placed before it that it can adjudicate upon. Once you have filed the right processes, the judiciary will not hinder you in any way at all. That the judiciary will be very happy to see that you have put the right things in place. Once you do that, you are good to go. But then you need also to learn to be patient in terms of the way the matter will go. You know, because what used to happen is that the docket or the court, the cases before the court most of the time appear to be much, and there are this clumsy issue of, you know, how to sift through from one case to the other. That's the challenge. And
they're writing longhand and all of that?
That is the problem which we have. And the earlier we come out of that, the better. And it's not rocket science for us to come out of a longhand process in the court. It's not a rocket science. It's just that political leaders are not being honest. Because we see what happens abroad, where in a matter of a week, you're through. It's a serious matter.
Right.
But here, you know, years will go by, and we lose at the end of the day in terms of the time, the money, and all that has gone in. You know?
Quite interesting. This is quite an educating conversation we'll be having today with Barrister Alexander Obo, who has been talking to us about public interest litigation. We'd like to say we appreciate you for these valuable insights.
Thank you so much. Thank you so much.
All right, let's draw the curtains here on Scale of Justice. This week, we'd like to say a big thank you to all of our viewers. This is Global Television. I am Uyi Agumofwegbe, and our broadcast of programs continues now.